I think we'll get started. Good afternoon or good morning, everyone. Really appreciate everyone joining today's webinar, Nonprofit Organization Data Privacy and Security, held by our Nonprofit Organizations Practice Group. And I'll be introducing our expert speakers in just a moment here. Just a quick note that we will be having another program on April 19th that is also going to be a webinar. The title of that is Playing the Long Game, Everything You Need to Know About Restricted Grants. So we'll have interesting, good speakers, an interesting topic to discuss in April as well. Going back to today's program, we're going to be talking about issues that so many nonprofit organizations face, and it's becoming a deeper and deeper concern and an area of risk for organizations when it comes to the data and other information that you hold and the ability to maintain protection of that and to comply with all the privacy requirements that are ever changing on the federal and state level. And so I'll be happy to go through our panel and introduce each of them now. First, meet Kelly Bastide. Many of our clients know Kelly well. Kelly works closely with many of our nonprofit organization clients on issues related to privacy and privacy law compliance, helping you with their privacy policies, helping comply with issues that may arise through contracts and those sorts of things. Kelly is the co-chair of our firm's Privacy and Data Security Group and has been with us for a number of years. And as I say, a great partner with the Nonprofit Organizations Practice Group. Also speaking today is John Banghart. John is Senior Director for Cybersecurity Services here at Venable. And sort of as they divide their world, Kelly's handling the privacy legal issues, and John handles a lot of the data breaches and other cybersecurity protection issues that may arise. Before coming to Venable, John was a cybersecurity program and policy analyst for NIST. And before that was working at CMS as a senior cybersecurity advisor. And again, John may be familiar to many of you when you've had the unfortunate situation of having a potential breach. John has been very helpful in helping our clients through that. Last on the panel is Nana Kwabena Abrefa. He's an associate with the Privacy and Data Security Group, graduate of Columbia undergrad and Georgetown Law, does a lot of work on a lot of the issues we're going to talk about today. I should have said at the outset, I'm George Constantine. I'm the co-chair of the Nonprofit Organizations Practice Group here at Venable. And again, welcome to you. And I think with that, I'm going to turn it over to John to get started.
Great. Thank you, George. And thanks to all of you for attending today. We really appreciate it. We've got a lot of great information for you. And so let's go ahead and jump right in. Nana, next slide. Thank you. So the agenda, I think George touched on some of this, but quickly, we're going to run through some cybersecurity background. I'm going to give you a little bit of picture of the threat landscape, and importantly, what are some of the trends that we're seeing around cybersecurity policy at the federal level, and how some of those, while they may not impact you specifically or directly, could impact you in ways that you may not always be anticipating. So we'll touch on that. And then Kelly and Nana will talk about state privacy laws, litigation risks, and at the end, we'll wrap up with a few key takeaways for you to help you manage some of these things better. Next slide, please. And keep going. Thank you. All right, so let's talk a little bit about the cyber threat landscape. And I think it's important to try and keep up to date with this because we hear a lot in the news. In many cases, there's really more than we can process. I work in cybersecurity and I can't even keep up with it. And for most of you who are not working in that space, you have your own things that you're trying to keep up with. So I'm not going to spend what could be all day talking about the threat landscape, but there are a few examples that I think are worth pointing out and a few things to consider. First of all, as George suggested too in his opening remarks, cybersecurity as a risk continues to grow, right? Regardless of what sector you're in, regardless of what your business is, you have a dependency on technology. You have a dependency on digital services. And as those services increase, as the number of devices that we're using that are connected to the internet continue to increase, so too does the risk, right? We call that the threat surface or the attack surface. Your organization, the more technology you have, the more dependencies you have on that technology, the more risk there is. Which is not to say that you should not be using technology, right? That's not the answer. We need that technology for a lot of reasons. But it's important for us to remain aware of the risks as we bring more technology and depend more on technology. Some examples of that, some of these you may have heard of over the last year or two. Colonial Pipeline was a big one, right? So this was an attack within the energy sector, considered critical infrastructure. Not only was there disruption to energy around the flows in the pipeline, there was national economic disruption, right? There was panic in many cases. And an example like that, attacks against our critical infrastructure, again, I realize most of you may not be in critical infrastructure, but when those attacks happen, they can impact your business. They can impact all of us. And so it's important that we consider what are some of the risks associated with that. Some of you may have been caught up in the Kaseya VSA. I hope not. But if you were, you're familiar with this one. This was an attack against a managed service provider, which of course, I imagine many of you are using for your IT and your security. Attack against those service providers can be a way that the bad guys can actually compromise lots of companies by only having to compromise one right out of the gate. And in this particular case with Kaseya, we know of at least over 1,000 other organizations that were impacted by that because Kaseya as an organization was compromised. So again, thinking about our partners. Health service executive, I work a lot in healthcare, so I have a lot of concern about this. There is increasing attention by bad actors on healthcare sector. They're trying to get information from organizations to use for ransom. We had a horrible one that's been ongoing in Tennessee, where pictures of cancer patients have been released and all sorts of just really unfortunate things. And so these bad guys are going after data. And one of the important things for you all is to think about what data am I holding in our organization that could be valuable. And then, of course, government. We had a situation in Costa Rica where the government was basically taken offline. State of emergency was declared, disruption to all sorts of services. And of course, we've seen that here in the United States with local governments being taken offline and certainly attacks against the federal government as well. Next slide, please. So just a little bit about some of the threat actors. You'll hear me use different terms. Sometimes I say bad guys, sometimes I say bad actors. The more sort of formal term is threat actors. I know we often use hackers, but it's more accurate to refer to the bad guys as threat actors. When we talk about non-state, these are generally criminal gangs, right? And you can see on the right-hand side, this is taken from one of the few good sources that we have of this kinds of data about complaints and estimated losses, just from what was reported to the FBI. And I guarantee you that that is a fraction of what is actually happening. But that's a pretty sobering number when you stop and think about over $18 billion in losses from cyber criminal gangs that are using business email compromise. This is one that I see frequently used against nonprofits, smaller organizations, are these business email compromise. This is where the threat actor sends an email that looks like it may come from the president or come from a board member or come from a customer. And people who are otherwise well-meaning may wire money, they may give their credentials, they could do any number of things. And this is a very lucrative approach for a lot of these threat actors. For others, it can be hacktivists, or what we sometimes refer to as patriotic hackers or threat actors. These are folks who may be motivated by geopolitical issues, such as we're seeing with the Russia-Ukraine war. They could be motivated by social issues and so on. And as I mentioned, these non-state actors, threat actors, are often motivated to attack critical infrastructure because they know that they're more likely to get a ransom paid, or they're more likely to be able to have an impact that could result in them making money. And to be clear, for the most part, these organizations, they want to make money. They are organized crime in the sense that they think about the return on investment when they're attacking a company. They think about how to automate their processes. It is a business for them, and it's important for us to always think about and remember that it's a business. These are not the Hollywood hackers that we often see sort of in the basement with the hoodie pulled up around their head, surrounded by monitors and doodads. These are organized gangs, and they're very good at what they do. Next slide, please. So nation state actors, of course, in contrast, these would be countries. I've listed a few here. Certainly, this is not a comprehensive list, but these are four that you'll often hear about: Russia, Iran, China, and North Korea. These are either threat actors working for the government directly, or and sometimes they're just sponsored or given resources by the government. Some of the activities, military or economic research and development. We've seen a lot of that with the Chinese government, with attacks on the US and elsewhere to steal intellectual property. So if you're in a situation in your organization where you've got intellectual property, that may be of interest, right, to foreign nations, because they want to take that, they want to give it to companies in their own region in order to improve their competitiveness. Profit is also a motive. North Korea is well known for this, attacking companies or organizations just to try and steal money, right? You can see that in North Korea, we think that their activities over the last several years, anywhere from 630 million to 1 billion that they've been able to get through extortion, ransom, and so on. Russia and Iran, we hear a lot about. Obviously, with Russia, we've heard a lot about misinformation, disinformation, campaign interference. Again, with the Ukraine conflict, a lot of geopolitical motivations there as well. So, for the most part, smaller organizations, unless you have intellectual property or something along those lines, or you're considered critical infrastructure, you're generally not going to be of interest to a nation state, but you will be of interest to commercially motivated, sort of the non-state threat actors. Next slide, please. So unfortunately, I have to talk about ransomware. No doubt this is something that you've heard about extensively over the years. If not, I'll give you a little bit of insight into it. As a reminder, ransomware, as the name implies, it's software that ends up on your computers that basically encrypts all of the data. Sometimes it'll steal the data first, any number of things, but it'll encrypt your data and you get a notice that says, hey, we're the bad guys. We've encrypted all your data. You need to give us money. And if you don't give us money, then you're never going to get your data back, right? Now, what's interesting is we've seen some trends that in some ways are positive. So we've seen the number of victims that are having to pay ransom has gone down. That's great news. And in part, that's attributed to just better practices like maintaining good backups. So that's great. So we'd love to see that. But what we've noticed is that while fewer organizations are paying ransom, the bad guys are going after higher value targets, right? They're going after critical infrastructure. They're going after hospitals. And so what that means is that the amount that's being paid is actually greater. And so it continues to be very lucrative for the threat actors. And of course, they continue to innovate, right? So I mentioned that sometimes ransomware will steal your information first. So often what they'll do is they'll encrypt all your data. They'll give you a ransom demand. If you refuse to pay it, or if you hesitate, they'll switch and they'll add extortion to the mix. And they'll say, well, look, we stole all this sensitive information. If you don't pay the ransom, we're going to release it. We now have seen double, triple extortion attempts. We also have seen situations where they may knock your websites offline or different services that you may be offering, really just trying to innovate, as much as I hate to attribute that word to criminals, but they're trying to innovate so that they can make the money that they want to set out to make. And this continues to be a significant problem. Next slide, please. So a few quick things just on what's happening within the US federal government and some places where they're focusing that in some ways will be relevant to you all. So one of the things we've seen come out of DHS, and in particular CISA, who's the organization within DHS that oversees cybersecurity for the nation, critical infrastructure, and so on, is a sense that we need to move the responsibility for, or at least some of the responsibility for managing cybersecurity away from small businesses, away from individuals, and put more of that responsibility in the hands of organizations that are developing software. Right. So these are your big IT companies, they're your cloud providers. And so there's some moves in that direction. And what that will mean for you all over time is that the software that you're procuring, the software that you're using, as more and more developers switch to doing secure software development, there's going to be less weaknesses, less vulnerabilities in that software. It's going to be harder to break into. So this is something that we're seeing a big trend. It's here in the US as well as overseas. So expect to see a lot more of that. And while there's not necessarily anything for you to do within your organizations, it is something that should have a positive impact. I'm going to skip over a couple. Expanding and improving information sharing. This is one that's sort of near and dear to my heart. I do work with organizations called the ISACs, the Information Sharing and Analysis Centers. These are really great ways of being able to coordinate with others in your sector, in your industry, other small businesses. There are all sorts of organizations that you can get involved in. Some of them are membership driven, others are just more voluntary. But there's great ways to go out, get involved, share information about what are your concerns, what are you doing to manage your cybersecurity, learning from others about what they're doing to manage their cybersecurity, learning about who's attacking who and what can I do, and so on. So a really, really great way of getting out there, getting involved to the extent that you can. And then, of course, international standards and regulatory harmonization. If you are a regulated entity, this is going to matter a lot to you. But again, even in cases where you are not in critical infrastructure, where you're not regulated, and I know many of you fall into those buckets, you're going to have partners that are, right? You do depend upon critical infrastructure. You do share your data with partners, whether it's cloud providers or other services who are holding your information, who may be regulated. Think about your bank, right? Your bank is a regulated entity, holds information. So all of these things, even though you may not be directly involved, impact how you manage your cybersecurity and impact the overall risk that we all share in this space. And so these are all positive trends. Next slide. So quickly to, I want to get over to Kelly. Speaking of that sort of things that may implicate or involve your organizations, even though you may not be in scope, there have been some real moves lately to increase the amount of incident reporting. Remember, I showed you a couple slides back, the stats from the FBI. We have very few good data sources about incidents. We're missing a lot. And so there's a big push within government, the US government, as well as in Europe and elsewhere, to mandate reporting of incidents when you have them. And so two here, big one, CISA, which is again in DHS. This will be largely again for critical infrastructure, but we don't know exactly how the rules are going to look and what all that may mean. We also don't know whether, if you're a partner of a critical infrastructure entity, could you be ending up in their reporting, right, if you're caught up in an incident that they had? Similarly with the SEC, that's obviously for publicly traded organizations, but the point is that there is a really dramatic increase in trying to do more incident reporting, more information sharing, so that we can get a better handle on this problem. So Nani, you can skip over the next two. I think I've gone long enough. And so Kelly, I'll turn it over to you.
Thanks, John. As George said at the top of the program, my name is Kelly Bastide, and I'm co-chair of the Privacy and Data Security Group here at Venable. Really excited to see a lot of registrants for the program today. I've spoken to this group in years past and largely not had a lot to say because nonprofit organizations have historically been exempted from a number of US privacy laws. However, there have been significant changes in the US, in the legal landscape here. And unlike in the past, a number of these changes do directly impact the nonprofit sector. So I've spoken in the past about the European Union's General Data Protection Regulation, the GDPR. A number of organizations went through GDPR compliance in the 2018 timeframe. If you're familiar with that law or went through that kind of compliance exercise, much of what we're going to say today on the privacy side will sound familiar. But the state laws that are arising in the US are not a direct cut and paste of European laws. Instead, you'll see some EU concepts that have been imported to the US with a distinctly US kind of flavor to them. So on this slide, this is just a timeline of what's going to happen or is happening in 2023 in the US. The California Consumer Privacy Act went into effect January 1 in 2020. And that was the first comprehensive or omnibus privacy law in the US. It was followed in short order by Nevada, which is a law. It was amended in 2021, which is a law with a much narrower scope. And that's where we were. But it takes us to 2023, where there's sort of an explosion of developments. Starting January 1 of this year, the CCPA was amended and it's become the CPRA, the California Privacy Rights Act. although it adopts the CCPA name again. So it's an amended CCPA. We'll talk about CCPA or CPRA just to distinguish the two different laws, but the law kind of at its base level is the CCPA. That went into effect on January 1 of this year. And Virginia's Consumer Privacy Act went into effect also January 1 of this year. The next set of developments will be in July when Colorado's law goes into effect and Connecticut's law goes into effect. Also, July 1 is the end of the enforcement grace period for the CPRA in California. And then the last development that we'll see that we know about this year will be at the end of the year on December 31st, when Utah's omnibus privacy law goes into effect. Okay, next slide, please, Nana. So this is what the landscape looks like or will look like at the end of this year. We're going to spend a lot of time talking about Colorado and Virginia because they're the laws that most directly apply to this audience. We're going to talk a little bit about California also, but you'll see of those 5 states that we talked about, Utah and Connecticut are, squarely exempt nonprofits. So those we're not going to discuss today because you can largely put them out of mind due to the broad exemptions in the law. So breathe easy in those states. Okay, so just to unpack a little bit how the different state laws that are coming into effect in 2023 exempt nonprofits. Let's start with the easy ones, Connecticut and Utah. So you'll see both of these states feature entity level nonprofit exemptions, i.e. very broad exemption for nonprofit organizations. And the law has no impact on any organization that's exempted here. So breathe easy in Connecticut and Utah. Those are states where you don't have to follow ongoing developments or pay, very close attention to what's happening in those states from an implementation standpoint. Of course, they may apply to your, vendors or third parties you work for who are for-profit companies. And you'll see, I think, the impact of that largely through contractual amendments or maybe some ways that those companies kind of challenge or change their compliance. But as an organization, you don't have to worry directly about the impact of these laws. Okay, next slide. So the news is going to get kind of worse as we go through the presentation. So let's talk squarely about Colorado and Virginia, the 2 laws that are going to be the focus of our discussion today. The Colorado Privacy Act does not have an express nonprofit exemption. Instead, it does apply to any organization or entity that conducts business in Colorado, and it defines conducting business as registering with the state. There is under the Colorado law, foreign nonprofit entities shall be considered to be transacting business or conducting activities in the state if required to file a registration statement with the Secretary of State. 501c3s are required to register with the Colorado Charities and Fundraisers database and thus would be covered, provided that the other thresholds in the law are met. Just some definitions to kind of level set for everybody. The laws will talk a lot about data processing. Processing includes a wide range of data activities, everything from active data processing, like collecting data, selling it, sharing it, but also passive activities like storing it. So if you are touching personal data, you're probably processing personal data. In addition, we're defining consumers here. It's basically a Colorado resident. There are some thresholds in the law as to how many Colorado residents' data you have to be processing. We'll talk about those in a minute. But consumer is someone who resides in Colorado and is acting in their individual or household capacity. So you have to think about not just named individuals in your CRM or your database, but unique website visitors, donors from Colorado. Are you collecting device identifiers through an app? Anything that uniquely identifies an individual coming from Colorado, that's going to count as a consumer contact. Okay, Virginia is a little different than Colorado. Virginia does have a nonprofit exemption that applies to nonprofits organized under Virginia law. It applies to 501c3, C6, and C12 organizations, but it does not apply to 501c4 organization. with a very, very limited or narrow exemption to that. So if you are a 501c4, pay attention to what we say about Virginia. If you're a 501c3, 6, or 12, you largely can put Virginia in the same category as Connecticut or Utah from your compliance perspective. Okay, next slide. So California and Nevada are even stranger when we talk about the scopes of the law. California, the CCPA, as amended by the CPRA, has retained the definition of business. A business is defined as a for-profit entity, so nonprofits are exempt from kind of holistic California exception. However, a business also includes another entity that has common ownership and shares common branding, like a common name, trademark, or service mark. So if your foundation is, for example, the nonprofit arm of a for-profit company, and you meet those ownership and common branding characteristics, that nonprofit could be pulled under the compliance umbrella of the for-profit business with which it is associated. There are also different kinds of entities that are recognized in California that aren't recognized in the same way as other states, including contractors or third parties. That's something that's unique to California. And those are not limited to for-profit entities, but can include kind of any kind of entity, right? But just note that in those cases, the compliance obligations are largely going to be contractual and not sort of the full scope of the law. And then we would be remiss to leave out Nevada. Nevada does not have an omnibus privacy law like the other 5 states that we've discussed. It has a much narrower law that applies to information collected online that's being sold or shared. The NPA in Nevada applies to operators, which is any organization that owns or operates a website or online service for commercial purposes, that collects data from Nevada residents and directs their activities towards Nevada. And the compliance obligations of this law are far narrower in comparison to the others. So we didn't want to leave it out, but it's not one that I think has the same kind of compliance burden as the other laws we're going to talk about. So we're going to focus largely on Colorado and Virginia today. In a moment, let me just give you the statutory thresholds for the laws before we transition over. Focusing here, all of the laws have statutory thresholds that are tied either to the volume of data that's being processed or revenue volume of data that's being sold or shared. The magic number in these states is 100,000. So again, even if Colorado applies to you in theory, you still have to be processing the data of 100,000 Colorado residents for the law to apply in actuality. So keep in mind those thresholds. It's a significant threshold. You'd have to be obviously operating at quite scale. Virginia, similarly, 100,000 residents is the threshold. California too, but remember California, you would be aggregated in with all of the data processing conducted by the for-profit business that's kind of bringing your nonprofit in. And then each of the laws would apply if you're engaged in the selling of data. And they generally look at things like what percentage of your revenue is achieved from data sales. So, more than 50% or sort of a minimum threshold of selling the data of 25,000 consumers in Colorado and Virginia are going to bring those laws, make them applicable to you. So over to Nana to talk a little more in detail about what Colorado and Virginia require.
Thank you, Kelly. So we're going to dive a little bit deeper into Colorado and Virginia's laws. And starting out, we'll just kind of focus on how these laws could apply to your organization. And so generally, these laws take similar approaches, and you'll see this throughout, but there are some key distinctions we wanted to point out. So Colorado, as Kelly mentioned, will apply to more types of nonprofits than Virginia will. And in Colorado, we see this construction of controllers and processors, which if you're familiar with GDPR, you'll recognize these terms as well. Virginia also applies these terms. So if an organization is directing or controlling the processing of business, they will likely be a controller and they will see direct regulations under these laws. Whereas if an organization is processing data on behalf of a business or a controller, they will be a processor. And then you will likely face most regulations through contractual requirements, and generally sort of assisting a business with their compliance. The Colorado law and Virginia laws also, they exempt employment records, job applicants, or business-to-business contacts. So those sort of personnel records would be cut out of the effectiveness. And then as discussed, Colorado will be coming into effect later this year, whereas Virginia is already in effect. These laws also take a similar approach to consumer rights and personal data. So Colorado and Virginia are rights-based laws, and so they give consumers rights to access, correct, delete, and opt out of processing personal data. Personal data is defined broadly under both of these laws and addresses information that is linked or linkable to an identified or an identifiable individual. And these laws also exclude information that is de-identified or publicly available information. And so both of those terms are particularly defined under the laws, and for de-identification, it also requires entities to maintain that data in that form and commit to not re-identifying it. And so controllers will have primary responsibility for responding to consumers' rights under these laws, whereas processors are generally relegated to assisting controllers in that role. And then both of these laws also establish authentication requirements. And so if a controller cannot authenticate that the requester is the individual whose data is in question, they're not required to reply to that request. And then Colorado diverges a little bit here. Colorado allows consumers to authorize an agent to act on their behalf and submit requests on their behalf. But similarly, the authentication requirement extends to this agent. So controllers could require agents to prove their authorization to act on behalf of a consumer. So next, we're going to dive into these access, correction, and deletion rights. And so again, these rights apply if they can be authenticated using commercially reasonable methods. And so in Colorado, if there is an access request, the controller must provide personal data that they maintain or process about the consumer. There's also this right to portability, which is this idea that the data would be transferred in a form that could be readily used by another entity. And this would need to apply to all data that the controller processes about the consumer in Colorado. For correction requests, the controller would need to correct inaccurate information about the individual. And the proposed regulations under Colorado's law would allow the controller to request information regarding the accuracy of the information that would be in dispute. And then lastly, for deletion in Colorado, the controller would need to delete all personal data about the requester. And there are certain exempted purposes that are also listed out under the law related to things like internal business processes or safety and security. And so in Virginia, we see a largely similar approach again. However, regarding portability, the data only regards data the consumer has provided to the business. And so we just wanted to flag this because this data set could potentially be narrower than the data set of all personal data a controller processes about a consumer. And then Virginia has not provided the same sort of additional detail on correction requests regarding what should happen if there's sort of a dispute about the accuracy. But Virginia would handle deletion requests in the same way as Colorado. And so next are these opt-out rights. And again, the laws take a broadly similar approach, and they define this right to opt out of processing for three distinct purposes: for targeted advertising, for the sale of personal data, or for profiling that would result in legal or similarly significant decisions concerning a consumer. So targeted advertising, which you may also be familiar with interest-based advertising or online behavioral advertising or cross-contextual behavioral advertising, refers to sort of the collection of information about a consumer across time and across websites or domains to predict preferences or interests about that consumer. In Colorado, the definition of sale refers to the exchange of personal data for monetary or other valuable consideration, whereas Virginia limits this definition of sale to only for monetary consideration. And then profiling in both states refers to the automated processing of personal data to evaluate, analyze, or predict personal aspects about an individual. And then Colorado refers to sort of a clear and conspicuous method to allow consumers to exercise this right. And we will also dive a little bit deeper into Colorado allowing certain signals to indicate this opt-out right. Virginia does not require the same specific language, but does require methods to exercise consumer rights to be presented in an organization's privacy policy. And so as I just mentioned, Colorado discusses universal opt-out mechanisms. This is not present in Virginia's law. This also may be familiar to some people as global privacy controls or opt-out preference signals. But the Colorado law comes into effect July 1st of this year, and until July 1st of 2024, controllers have the option to honor signals from universal opt-out mechanisms, whereas on July 1st, 2024, controllers will be required to do so. The Colorado Attorney General is ordered to issue technical specifications regarding these opt-out mechanisms, and the current proposed regulations, which the Colorado Attorney General actually submitted yesterday for finalization, do discuss some of these technical specifications. And so some things include that an opt-out would have to allow a consumer to communicate more than one opt-out right. So for example, to opt out of targeted advertising and sale. And also that these opt-out mechanisms should not unfairly disadvantage any controller. And so the regulations which were submitted for finalization yesterday, the Attorney General expects to be posted to the register later this month and to be in effect by July 1st, 2023. The Attorney General is also directed to publicize a list of approved opt-out mechanisms. And so organizations in Colorado would only be required to comply with opt-out mechanisms that were deemed sufficient under the law, and those mechanisms would also be published to this list. Both of these states also discuss an appeal right. And so if an organization denies or refuses to act on consumer rights requests, they must provide instructions on how to appeal the right. Colorado offers a 45-day initial period to reply with a 60-day possible extension, whereas Virginia does not mention an express extension, but gives 60 days initially to reply. And both cases involve explanation of the decision. In Colorado, for any disposition of an appeal, the response must let the appellant know about the ability to contact the Attorney General with a complaint, whereas in Virginia, an organization only needs to provide contact information for the Virginia Attorney General if an appeal is denied. So for sensitive data, Colorado and Virginia take a similar approach to the choice that's offered to consumers, but then they differ in how they define this term. So both states take an opt-in consent approach, which means that a controller or a nonprofit would have to obtain consent from the consumer before processing sensitive data. And so this would need to be a clear affirmative act, and Colorado goes on to sort of lay out a few instances where that they would not consider as consent. So for example, accepting broad terms. And the proposed regulations in Colorado also add a little bit more color to what freely given, specific, informed, unambiguous consent means. Colorado takes a broader sort of sweep at sensitive data. And so you'll see there's a lot of similarities here, and they discuss personal data that reveals racial or ethnic origin, religious beliefs, mental or physical health condition or diagnosis in Colorado, whereas Virginia only mentions diagnosis. Colorado mentions sex life and sexual orientation, whereas Virginia limits it to sexual orientation, and then both refer to citizenship or immigration status. Both also talk about processing genetic or biometric information and processing personal data from a known child. Virginia specifically references precise geolocation data. Colorado does not make the same reference, but in the proposed regulations, it discusses sensitive data inferences. And so this could include inferences derived from precise geolocation data. For example, if somebody has gone to a religious institution or a health clinic, and could also derive from inferences from web browsing data. So both states also include certain transparency requirements. And so these are things that you might see in a privacy policy, and include things like categories of personal data to be collected or processed, categories of third-party recipients of this data, the purposes for processing, how and where consumers can exercise their rights, and if applicable, if an organization is selling or participating in targeted ads, sort of notice of that fact and how a consumer could opt out. Both states also require data protection assessments. And again, the approach here is largely similar. So in both states, these assessments are required when processing is for targeted advertising, when there are sales of personal data, where there's profiling with an reasonably expected risk of substantial injury. And so this could include unfair treatment, disparate impact, financial, physical, or reputational harms, or certain privacy invasions that would be considered reasonably offensive. It also applies where there is processing of sensitive data, or in other cases where there is a heightened risk of harm to individuals. And these assessments should aim to weigh the benefits and the risks, to consider safeguards, and to sort of determine that the benefits outweigh the risks as those safeguards offset the risks themselves. And then in Colorado, the Attorney General can request these assessments at their discretion. In Virginia, the Attorney General could only request these assessments in connection with an investigation. So to wrap up Colorado and Virginia, we want to just discuss who enforces these laws. Both states give exclusive enforcement authority to the Attorney General. Colorado also extends this to the state district attorneys. Both include a cure period. Colorado's is 60 days, but it will sunset on January 1st, 2025. Virginia's is 30 days and does not sunset. As discussed, Colorado grants rulemaking authority, and the rules have now been submitted for finalization and are expected to be in effect on July 1st of this year, whereas Virginia does not grant rulemaking authority. And then fines in Virginia could be up to $7,500 per violation. The Colorado statute does not explicitly lay out fines, but these violations could also be considered deceptive trade practices and therefore be fined up to $20,000 per violation. And neither law includes a private right of action. So I will now hand it back to Kelly to discuss California a little bit.
Thanks, Nana. And for those of you who are looking for CLE credit, I will give you the CLE code now. It's Security 2023. Again, the CLE code is Security 2023. So let's talk about California for just a couple minutes. Again, it applies in kind of a unique use case where a nonprofit is sort of attached to a for-profit business, to use California's terminology, that falls under the law. Move to the next slide, please, Nana. So the CCPA has been in effect since 2020, but the substance of the law changed a bit in January of 2023. So now we're in the CPRA, and you'll see it has added some additional rights, including a right to correct and a right to opt out of sharing. We'll talk about what that is in a minute. There is now a sensitive personal information definition in California that is similar to the ones in Virginia and Colorado that Nana just discussed. It adds the GPC requirements like Colorado. And most distressingly, the 30-day cure period has moved from being mandatory to discretionary. It's enforced now by a new agency called the California Privacy Protection Agency. They've already been stood up and staffed, so we do expect them to be active when the grace period for enforcement expires on July the 1st. Okay, so much like some of the other state laws we've discussed, the CPRA has the right to know or access, correct, delete the opt-out of sales and sharing. Enforcement will begin in July. These provisions are, similar, have a lot of similarities to the other states that we have been discussing. So I think we wanted to just take a couple minutes to highlight what's unique about California. One thing that's unique about California is created a new definition under the CPRA of data sharing. Sharing is a specific use case, so it means disclosure, effectively, of any personal information to a third party for cross-context behavioral advertising, whether or not for monetary or other valuable consideration. This largely has is to resolve an ambiguity in the law. California already had a very broad definition of sales that included some of these advertising use cases. A lot of questions around the gray area about which advertising use cases fell under sales and required an opt-out. So they added a definition that made express that there's also an opt-out from sharing for cross-context behavioral advertising. This is targeted advertising that cuts across different websites, different brands, different applications or services. We largely think of online cookie collection as the engine that facilitates this kind of advertising, which is true, but it could also apply to opt-outs from offline sharing. For example, if you share a list of your customers, consumers, donors with a third party for lookalike modeling, where they're trying to find other individuals that resemble the profiles of your existing donors, that's cross-context behavioral advertising and would also be subject to an opt-out. Okay, so transparency, privacy policy disclosures. California, you'll have to add links to web pages that say do not sell or share to update the current do not sell link if a web page already has it. There's also now a requirement to have a link to limit the use of sensitive personal information. There's ways to bundle those links under a single link titled Your California Privacy Choices. If you look at the footers of a lot of web pages, you'll see these links. And there are also in the proposed regulations under the CPRA, businesses will have to honor opt-out preference signals. Sometimes we call this the GPC. Nana talked about in Colorado. Colorado has fleshed out what this requirement looks like in a little more detail and are poised to give us a little more on that. They have committed to provide a list of approved GPCs. So if your web page administrator says, okay, well, which signals do we have to honor? Colorado is going to give you a list. California has been a little more cagey about what they mean by this, except they are going to enforce against web pages that do not honor opt-out preference signals. So more to come there. Next slide. California now has a sensitive personal information definition. They have been there's this right to limit the use of sensitive personal information, but it applies only when the sensitive personal information is collected or processed for the purpose of inferring characteristics about a consumer. And that would be required to limit the use of my sensitive personal information link on a homepage. You see the definition there on the right. It shares the data elements that we saw in Virginia and Colorado. Again, there are slight changes between the states, but largely includes the same definitional aspects. It also includes the data elements that are considered sensitive for data breach notification purposes under the Colorado law. Okay. I mentioned that there is a new agency in California that's tasked with enforcement of the CPRA. They can act upon complaints or on their own initiative. The Attorney General historically, in the 2 years that the CCPA has been in effect, they have engaged in sweeps. So they were interested, for a while in loyalty programs run by grocery stores. They sent letters to every loyalty program grocery store that they could find to seek information. They've done this in other industry sectors as a way to look at how elements of the law are being implemented by an industry sector that they think is largely impacted. No reason to believe that they won't continue that kind of enforcement activity, but they'll now also look at complaints by third parties. As I mentioned, enforcement is subject to a discretionary 30-day cure period. And the CPPA will also continue to provide us with regulations. One thing that's really annoying about California, it's the only law that includes HR data or B2B contact information. They have not issued regulations that are specific to the employment context. Hopefully they'll do so in the future. But, there are a lot of questions that remain to be answered by regulation. There's also a limited private right of action for data breaches under the CPRA. There is a 30-day cure period, but requires implementation of reasonable security procedures following a breach. There's kind of some interplay about when you can actually file a lawsuit post data breach. So we'll look to see how that kind of works its way through the courts once the law is active for enforcement on July 1. Okay, so let me go back to Nana just to talk about Nevada for a couple minutes.
Yeah, so just to run through Nevada quickly, again, this law is much more narrow in scope. So it originally passed in 2019 and amended in 2021. As Kelly ran through before, it applies to operators and does not exempt nonprofits. For covered information, this may look similar to the sort of personal information definitions seen elsewhere, but it discusses specifically name, address, email address, phone, social security number, and then identifiers or information in combination that could identify. And the Attorney General has enforcement authority, and there's no private right of action. And this law has been in effect since 2021. And then again, the focus here is on transparency. And so a privacy policy is required to make certain disclosures. And so it includes the categories of personal information collected and third parties that may collect information about an individual. There are not the same rights here, except for the opt-out of sale. And sale here is defined narrowly as the exchange for monetary consideration. The law also addresses data brokers, which are entities that are purchasing information about Nevada residents and then reselling that information. So I'll pass it back to Kelly to discuss some litigation risks we're seeing.
Yeah, so I don't want to cut into the last part of John's time to wrap up, but there were just 3 other trends. We've been talking about the state laws. They're animating a lot of the privacy discussion these days, but there are other existing privacy laws that apply. And we are seeing some litigation risks coming from old laws being applied in new ways. And we just wanted to highlight 3 of those really quickly here. Nana, if you move the first slide. The first one we want to talk about is the Video Privacy Protection Act. It's an old law that prohibits the disclosure of personally identifiable information of a consumer by a videotape service provider. So it's the content of what somebody is renting from their videotape service provider, truly intended to apply to the blockbuster videos that were around in 1988 or the mom and pop video rental stores. You might be wondering why we are talking about this. Over the years, courts have applied the VPPA more broadly, not just to physical media, but to online streaming platforms. So Netflix is a videotape service provider under the VPPA. Where we're kind of seeing the enforcement and the litigation risk are enterprising plaintiffs' attorneys who are filing VPPA litigation against any website that has embedded video. You all probably have embedded video on your website, whether it's a clip of your good works or you were featured on the news or something like that. We're just seeing a wave of litigation around embedded video on web pages. The kind of genesis of the claim is that if you have an advertising tracker or pixel on there, the web page might have the name of the video embedded in the URL string. So somebody clicks on the video and now it's, organization.org/puppiesandkittens.html. And that string is going to a third-party advertising provider. They are alleging that that is disclosure of video viewing information in violation of the VPPA, which requires consent for that kind of disclosure. There are statutory penalties of $2,500 per violation. It's kind of a new vector that we're seeing. I don't know that there have been any definitive. There was one motion to dismiss in New York just a couple of weeks ago, but these cases settle largely before they're decided by courts. So it's a place where we're just seeing a lot of litigation filed these days. Okay. The next one, wiretap laws. Every state has a wiretap law, and there's a federal wiretap law. It applies to the interception of electronic communications. There are laws or rules, around some are one-party consent jurisdictions, other are two-party consent jurisdictions. How does this apply today? So this has come up around something called session replay software. It's a kind of analytics. Many of you may have it embedded on your webpage. It effectively, from your perspective, would show, current analytics would show you where a user clicks, what the most read stories on your web pages are, Maybe if somebody starts to fill out a form and abandons the form. Session replay does a little more, so it can show where the mouse perhaps hovered from a website visitor, where the web page like hung up, or maybe they back button because something was taking too long to load. And we have seen the use of state wiretap laws alleging that this is an electronic communication, i.e. the website visitor and the website, and this is being intercepted. Unfortunately, this was given new life because there were decisions in the Ninth and the Third Circuit that interpreted California and Pennsylvania law respectively to apply to session replay software in theory, leaving open the question of whether they had consent from the party, i.e. were the privacy policy disclosures clear enough. So again, an area where we're seeing a lot of litigation filed, and they could file against anybody, even nonprofits. Okay. And then the last one is BIPA. You've probably heard about this. This is the Illinois Biometric Information Privacy Act. It requires any entity to have consent before processing biometric information. The definition of that is there. Why BIPA has been so damaging are the statutory penalties and liquidated damages. And just only a couple weeks ago, the Illinois Supreme Court ruled on how to count claims for BIPA in a case against White Castle, saying that there is a separate claim every time an individual's biometric identifier is transmitted. White Castle was using, I believe, fingerprint technology for employees to clock in and out of their shifts. So every time that fingerprint was tapped by every single employee, that was a $5,000 damages claim. It equaled hundreds of millions of dollars. And the Illinois Supreme Court said, we understand that the kind of claims, the numbers here are eye-popping. Tell the legislature to fix the statute if you want that changed. So BIPA is going to increasingly be important. Sorry, John, I think I took your time.
No problem. Just 30 seconds. Nana, go ahead. Sorry about that. Got a phone call coming in on my phone. So yeah, just very quickly, we touched on some of these things. I realize folks need to go. Just remember that managing cybersecurity risk, all of these things we talked about, from the state perspective, underneath all of these is your ability to manage your own data, secure your own data. Treat that as an organizational risk, right? It's not a technology risk. It's not the IT group's problem. It's an organizational risk. Remember what I said about information sharing. Find organizations that you can get involved in to do that. When you can, take advantage of cloud services. They can make your lives a lot easier in a lot of cases. They're not a silver bullet, certainly, but can be very helpful, particularly for small and medium-sized organizations who may struggle to have the resources to do a lot of things on their own. And finally, where you can, implement contractual third-party cybersecurity baselines. Some of the examples I cited earlier are about incidents that will occur at your partners, not even just you, but you can have detrimental business impacts as a result. So think about how to work with your partners in a way that's mostly secure as possible. Next. I think it's back over to you.
I think that we are at time, but we have a couple tips here just to talk about preparation for these privacy laws. If you find that you're falling under their scope, obviously assess whether they apply to you. You will have to update your external facing privacy policies, and as well as develop some internal processes to make sure that you are able to meet individual rights requests. And of course, certainly assess the third-party technologies that are operating on your web page. That's where we're seeing some litigation risk arise. Let me give the CLE code one more time. It is Security 2023. Thank you all for your attention this afternoon. We will talk to you soon. Thanks.